Hello, thank you for joining us today as we're going to answer as many questions as we can get to today about immigration. My name is Mercer Colley. I am a partner here at Colley Forsyth, and I'm a board certified immigration specialist here in North Carolina. And I'm joined by Raquel as well.
Yep, I'm Raquel Fernandez. I'm an associate attorney here at Colley Forsyth, and I'm excited for this TikTok Tuesday, Facebook Tuesday as well. Thank you for joining us on the different platforms. We're excited to get to your questions today.
Absolutely. And so every Tuesday at noon, we're here answering questions that you may have about immigration. And the best way to do this is if you have a question, go ahead and post it either at Facebook or post it here on TikTok, and we'll start answering your questions here shortly.
Yep, and thank you guys for sharing the live video as well. I see Vanessa Castillo shared the video here on TikTok. If you're watching on Facebook too, and maybe you don't have a question, but you may have friends who have immigration questions, go ahead and share the live video. Make sure to give it a thumbs up, a like, and I know that's going to be able to help reach more audiences that have questions.
Absolutely, and that's why we do this. Is we know that there are so many questions out there about immigration. There's so much confusion. We want to make sure that people have answers and they're able to navigate all of these situations, knowing what their rights are, knowing what they need to do. And so that's why we're doing it here. Is just get as much information as we can out so that people know what they can do.
Absolutely, and we have our first question here, and it's from Vanessa. Vanessa, the one who shared the video. So thank you, Vanessa. And she asks, ¿Cuánto tiempo? So how long does the waiver take to process? So how long is the waiver taking to process? She didn't say what kind of waiver.
Okay. So first, Vanessa, there are different types of waivers. One of the most used waivers is called an I-601. That's the form. And so we'll focus on that one since that's probably the one you're talking about. But a 601 waiver, 601A waiver is filed here in the United States. And right now, current processing times shows that it's taking about a year. So if you filed it, assume that it's going to take a year. A lot of the reason it's taking that long has to do with COVID. Once COVID hit, things really got backed up at immigration. And so they're just getting to a point where they're getting over that. So we're hoping it will start speeding back up. But right now, if you're getting ready to file or you just filed, in your mind, go ahead and assume it's going to take me a year. So I need to get ready for that.
Yep, and I actually got that question yesterday too. So I know it's a very popular question because there are very many people who have been waiting to be approved. We hope it'll be soon. And we also have a question here from Vinicio Peralta, and he is wondering if there is any way or any kind of bill or congressional help that will help people get their papers or legal status.
Sure. And what I can say is we are hopeful. Unfortunately, I've been saying that for over a decade now, that I'm hopeful that Congress will start doing things that will help people and bring some clarity to immigration. So right now, there have been several things that have been attempted, but nothing has gotten through. And the one I'm most hopeful for is that Congress will do something to help the dreamers, or which are the people that currently have DACA or are eligible for DACA, of giving them a solution where they can get their green card. That's what we're hopeful for, because that seems to have support by both parties. And so it's just a matter now of putting it in a package and passing it so that it gets through without having so many other things attached to it. Because that's what tends to happen with immigration, is you get an immigration law that people may be supporting, but then this senator adds that, and this congressman adds this, and this person. So by the time it comes up for a vote, there's so many other things besides just immigration that sometimes that causes it to fail. And so at this point, I can't say yes, there is something that's going to pass, or I even know of something that's that's looking likely to pass, but we're always hopeful.
Absolutely. I also have a question here from Ana Villegas. She says, "Hi, I have 2 entries to the USA, both when I was a minor. Can my daughter file a petition for me?"
So, Anna, that's a great question, and unfortunately, it's a fairly complex question. So, having multiple entries into the United States, if they're both without a visa, can have some pretty severe consequences. So, we need to have more information. So, what can happen is if you come in the United States without a visa and you stay here more than a year and then you leave the United States, that creates what is called a bar. So at that point, there's a 10-year bar. You're not supposed to come back in the United States for 10 years. If then you come back into the United States without a visa that second time, and then you leave again, that creates what's called a permanent bar. So my recommendation is if you have a U.S. citizen daughter that is 21 or is getting ready to turn 21, that you contact us so that we can walk through everything to see if you are eligible or not, because it is a complicated situation. But having entered twice, that does concern me. So I'd want to have more information to be able to make sure we're giving you the exact right advice for your case.
Yep, and you can give us a call, Anna, if you're interested. You can go over to CF Immigration's page right here, and the phone number is listed in the bio. It's also listed in my bio. It's 704-522-6363, and we offer free initial consultations. And I also have a question here from Carla Villegas, and she says that she got married 6 months ago, and they approved her I-130. So, wow, congratulations. Yeah. That's fast. Okay. Oh, the comment just got away from me. Okay. She's wondering if she needs to get a waiver. And she says a waiver for illegal. So maybe illegal entry. But she says she entered with a visa. So she's wondering if she needs a waiver for her unlawful presence, perhaps.
Perhaps. So, Carla, part of it's going to depend on who's filing for you. So, I know it's a spouse. If your spouse is a U.S. citizen, that puts it in a different category than if your spouse is, say, a permanent resident. If your spouse is a U.S. citizen and you entered lawfully with a visa, then you should be able to go ahead and process everything in the United States, which means that you would not need a waiver. If you've overstayed a visa and you leave the United States, that's when you need a waiver, because leaving the United States is what causes that 10-year bar that we were just talking about. So if you, again, entered with a visa, you lawfully entered, were inspected, and you haven't left since that entry, and you're married to a U.S. citizen, there's a very good chance you could be able to do everything here in the United States to obtain your green card, and you don't have to leave. If your husband or spouse is a permanent resident, at that point you need to give us a call, because that would mean that you have to leave the United States. That would create some other issues, and at that point you may need a waiver. So my recommendation is to give us a call to go through that. But that's a great question, because it's key that you entered with that visa and that you keep that information. So make sure you hold on to your passport with a stamp, because that is crucial.
And we have here a question from Brother Louis, but I'm not sure if the question is completely in the one comment. He says, I guess he's wondering if he's able to help someone with a medical condition who hasn't been legal in the U.S. So, Brother Louis, we'd have to know what your status is and what your relationship to this person is to see if possibly you could petition for that person. So if you can let us know a little bit more information in the comments, we'll be able to answer that question. We also have a question here from Boss Baraducci, and this person asks, do you all deal with LPR waivers for criminal convictions living in USA?
And so, yes, we actually, our firm handles immigration of every kind. So we do family, business, removal, and we also work with what's called crimmigration. So kind of what you're talking about here. So there are certain crimes that will make people inadmissible, so they can't come in the country. There are also certain crimes that can make somebody deportable, so they can be removed from the country. There are waivers that can get you around those, and those are 212H waivers typically. That's the law that revolves around it. And so with those, we can waive certain crimes so that the person can either get their green card, or if they already have a green card, they are allowed to remain in the United States. And so we need to talk with you about that, because with waivers, there are different requirements. So if you are a permanent resident, for instance, you have to have lived in the United States for a certain period of time and had your green card for a certain period of time. If you're not a permanent resident, it's a different period of time. And so because of that, we need more information to be able to say what type of waiver you're eligible to receive, and do you have the relatives. So a lot of times you have to have qualifying relatives in order to be eligible for the waiver. So we need more information, but yes, we definitely handle waivers, whether they relate to unlawful presence, crimes, whatever the situation, we definitely do waivers.
Yep, and you guys can reach us at our phone number listed on either profile here to give us a call for a free consultation. And I also see we have a question from Como Talibu, and he asks, how long does it take for an I-130 to be approved? Mine was submitted April last year, 2021. So it all depends also on where you filed. I just looked up on uscis.gov, and you can put in the form I-130, and then you can select your field office, and it gives you an estimated date range. So I selected Texas Service Center, and then it'll tell you based on your relationship to the person. So this one is U.S. citizen filing for a spouse, parent, or child under 21. And it's saying that it's taking about 11 months to 14 and a half months. This is just an estimate. It could be sooner. As we saw, somebody in the comments said that they got theirs approved within a few months. So it all depends. Hopefully you're noted. Your decision will come there. It's almost been a year.
Exactly, yeah. If yours was in April, and especially if it's at the Texas Service Center, that absolutely, it should be any day now. So what you can do is, like Raquel was saying, they're sent different places. If you look on your receipt notice on the bottom of it, you can tell which service center it was sent to. So you can go to what Raquel just said. You can go to that website, pull it up, check it, and you can see the exact time that they're saying it takes. I'm going to phrase that. It's not exact. It's 11 months to 14 months, so it's not exact at all. It's a long period of time, but you're able to at least see what that service center is saying that they're doing.
Definitely. And we have a really great question here from Crom899, and he asks, how hard is it to overcome the 10-year bar and re-enter when the reason is a drug charge?
So if you have a 10-year bar, a lot of times those relate specifically to either having an order of removal or unlawful presence in the United States. Drug charges are a little different, because drug charges there's typically not a time limit on those. So that would be a different type of waiver. So we'd have to look to see. Most waivers in this type of a situation, they're based on almost always, there are some exceptions, but usually a waiver is going to be based on you having a relative that is close enough to you, so like a spouse, a parent, something like that, they are either U.S. citizens or permanent residents. And what we do with waivers is we have to prove that it's going to be an extreme hardship to your relative if you're not allowed to re-enter the United States or to remain in the United States. So waivers like that are very it depends on the facts. And so if your family member will suffer an extreme hardship, then those waivers can be very successful. We've had a lot of good success with our waivers, but it really depends on that particular facts. And then also they can consider what the reason is that you need the waiver. So if it is for violating immigration law, and it's happened a lot, or they can look at the violations. If there's a criminal history, they can look at that. So they can balance as well and say, do I want to give this waiver because of this person's past, or do I want to not want to give this waiver, and then also relating to the family member. So those two things come into play, would be hardship to your family member, and then also just what is the reason that you're being held out of the United States or not allowed to come back. So those two are critical, and that's what we look at and analyze when we start working on waivers for different people.
Yeah, it's definitely a recommendation for you to help you with that, because we understand it can be very complicated to find the right kind of evidence to prove all that. So we definitely recommend for you to at least do a consultation and get more information on this.
Absolutely. And it's interesting, we had a lot of questions about waivers today. And so waivers are one of those things that it's very hard to give general advice, because waivers are very specific to each person's facts and each person's family, and what can we prove would be a hardship. So
yeah, and I posted a video yesterday on TikTok about the 212 waiver. So that might be where it's coming from. It's good that, these tiny, few second long videos will leave you with more questions, because that way you get to learn a little bit more. And thank you guys for joining the live. And of course, thank you, Attorney Mercer, for taking the time to answer all these questions.
Absolutely. That's why we're here. Answer as many questions as we can, and bring some clarity. Maybe not complete clarity, but at least bring some clarity to immigration, because it can be fairly complicated.
Absolutely. And we do have another question here. It's a very common question. And she asks, this lady said that she has a U.S. citizen daughter who turned 21, and she's wondering if her daughter can petition for her.
So yes, that's a great question. A U.S. citizen child over the age of 21 always has the right to petition for their parent. So the short answer there is yes. It gets a little more complicated when you have to start looking at the process for getting the green card, though, because if you entered the United States without a visa, then there's going to be issues with leaving the country and coming back, because if you entered without a visa, you can't get your green card here in the States. You have to go back to your original country. Now, as were some questions we answered earlier today, if you entered with a visa and that's your only entry, and you still have that proof, or even if you don't have that proof, we can get the proof for you. But if you entered with the visa and your passport was stamped when you came in, and now your daughter has turned 21, then yes, there's a very good chance that she would be able to do the whole process with you here in the United States without having to leave. Another thing to keep in mind is, if you did enter without a visa and you only have one entry into the U.S., and your child is 21, U.S. citizen, and a member of the military, then there are some other solutions for you, because there's some things called military parole in place. So we can take that first step, get you the paperwork that you need, and then you can file to obtain your green card. So the answer, it's a very long answer to be a short answer, but the short answer is yes, your daughter can file, but the key is going to be, are there anything that's going to block you from getting the green card? And so that's the part we need to look at and be careful with.
Yep, and you can schedule a free consultation so that we can talk to you more and find out more if you so desire. We also have a question here from JMV, and this person asks or states, They had voluntary departure 20 years ago. He's married to a U.S. citizen, and he's wondering about a motion to
So, yes, a motion to reopen is a possibility. If you took voluntary departure 20 years ago, then when you did not leave, that voluntary departure became an order of removal. So just want to make sure you understand that currently there is an order of removal through the immigration judge, because anytime an immigration judge gives voluntary departure, at the bottom of their order, they're saying if you did not leave in time, this becomes a final order of removal. So there is an order of removal. And so there is a possibility of getting the case reopened. Now, if you're married to a U.S. citizen and you're going to have to go back to your home country in order to process, there's a certain order that we would recommend doing it so that you time everything perfectly. So basically your spouse file for you first, then we start looking at the possibility, do you need a waiver, maybe working on the waiver. Then we step into trying to do the motion to reopen to see if that can be granted, and asking for voluntary departure a second time. If for some reason they will not reopen it, then there is a second waiver that is available to get rid of that order of removal so that you would be able to obtain your green card. So you could get a motion to reopen. What we need to do is we look and see what fits your case best, because whether it should be a motion to reopen, try to get it reopened and get the judge to grant another voluntary departure, or to just go straight for the waiver. So we'd need to look at that. But yes, that you're absolutely correct to ask that question, because something needs to be done with that order of removal in order for you to move forward with your green card.
Yeah, really great question. And he also adds that he has a critical health problem, so that could be useful for his waiver as well, possibly. They include information about that.
Absolutely. And so with that, so that's a great point, Raquel. With waivers are focused on your family members. And so is it going to be a hardship to your family member if you're not here? But we can also use the fact that you have a serious health concern or a health issue to say that it's going to be a hardship on your family member if they have to, for instance, have two households, one in one country, one in another country, or if they have to pay for all of the expenses out of the country because your insurance is here. So there are a lot of things that can be used and utilized that way. So even though it's you that has the medical condition, we still may be able to argue that that's going to be an extreme hardship to your relatives. That's a great point.
Yep. And we have one final question here, and it's also regarding a waiver. So I'm excited to say this one, also from Carla Villegas. And she says, I have a 2-year rule in my visa, possibly a student visa, but we're not sure. Do I need a waiver before my adjustment of status, or do I have to leave the U.S.?
So what it sounds like you're talking about is called a J visa, and J visas have that in the visa sometimes, that there's a requirement that after you complete the J, you have to go back to your home country for 2 years before you can come back to the United States. Also, if you're filing for trying to get a green card here, say through marriage or something like that, once you get to that point of getting the green card, they're going to say the same thing, is that no, you have a 2-year residency requirement. You have to go out of the country for 2 years before you can get your green card here. Now, to your point, yes, there are waivers for this as well. There are different types of waivers. Some are called no objection letters. That's where you get something from the consulate of your country that says, we don't object to this person not returning home, and allow them to go ahead and get a green card. There's also hardship waivers. What we've been talking a lot about today, that type of thing, is that you can waive that 2-year residency requirement by showing that it's going to be a hardship to your spouse, to your parent. I keep freezing here. It's going to be a hardship to your spouse, to your parent, if you're not allowed to remain in the United States and get the green card. So in that case, it sounds like it's a J visa, and if on your visa it says you have that 2-year residency requirement, then yeah, that you will need a waiver in order to get a green card.
Yeah, really, really great questions. I'm glad this almost the entire live had to do with waivers. So I'm going to definitely upload this onto YouTube if you guys missed any part of it. We may have already addressed your question if we haven't been able to get to it. So make sure to check out our video on YouTube. I'll be uploading it. And it'll be right here. You can go on CF Immigration. The link in the profile, it'll take you straight to the YouTube, and you'll be able to subscribe, ring the little bell so it'll notify you once it's uploaded.
And we just had a question pop up here as well, and it says, can they deny your visa if you left the country without advance parole? And so it's a great question, and it depends on the situation. With most applications, so for instance, you may be talking about an I-485. That's the application you file to get your green card. If you leave the country without advance parole while your I-485 is pending, then the government assumes that you have abandoned that application. And so at that point, that would be something that you have to look at. And so if it was, so it may have been DACA. So if it was under DACA, then it depends on what visa you are applying for. But if you are in DACA, if you are in that program and you left without advance parole, yes, there's going to be a difficulty getting back into the United States, because at that point, you don't have the documents to get back in. So if you have DACA, you must have the advance parole first. But typically, if you have applications pending and you leave the United States, then if you leave the United States without that advance parole, then yes, they can say that you've abandoned your application. And so if you applied for, so it looks like you're applying for a conditional residency. So if you had put in the I-485 and left the country before you got your advance parole, then at that point, yes, they can go ahead and deny your I-45, especially once they figure out that you have left the United States.
Yeah, really.
And this one said, so if you're outside of the United States and somebody applied for you, then you should be consular processing. So it should be going to your consulate in your country. And so at this point, if it's your relative that had the petition pending or had the application pending, then that he should not have had a problem with the I-130. So if it's I-130, that belongs to him. So you leaving or coming doesn't matter. It's when you apply for the actual visa itself.
And I also see a question that we can answer here really quickly. What year are they checking right now for U visa? So right now we're seeing that they're getting back to or making decisions on U visas from 2016. So it's taking about 6 years to get that decision.
Yeah, I think the latest we had, I think we had one come in this month that was done in, wasn't it March of 2016?
I think so, yeah.
So I think we're feeling pretty comfortable saying March of 2016, because we were hearing February. Now we're into March. And so we had quite a few that were done February of 2016. Now we're starting to see March of 2016. So yeah, that's about how long it's taking to get the final answer.
Yeah.
What about deferred action?
I'm not sure about deferred action.
And so I think deferred action is 2017. So we're hoping that they'll start moving up a lot. But if you had your application pending in 2017, hopefully you'll be getting deferred action here soon as well.
Yeah. And if you guys have any additional questions, or we didn't have to get to your questions today, please remember we offer free consultations. All you have to do is call the phone number, set up the appointment, fill out the intake, and it's absolutely free. and we look forward to hearing from you if that's what you want to do. Thank you again, Attorney Mercer Colley, for taking the time to answer so many amazing questions, and thank you to everyone who left their questions in the comments.
Absolutely. Thank you, Attorney Raquel, for being here with us today. Hope the information was beneficial. And like she was saying, if you want to join us here next Tuesday, we'll be right back here answering questions in English. If you'd rather have them in Spanish, join us here on Friday at noon, and we'll be able to answer those questions for you.
Yep, definitely. See you guys on Friday.
Everybody have a great day.
Bye.